Okay, thanks everyone for coming today. So, I'm Christine Van Geyn. I'm the interim executive director of the Canadian Constitution Foundation, which, as you all know, is Canada's leading and most principled civil liberties organization in Canada. And we're here to do this emergency town hall about Bill C-9. There, of course, that this is the new federal liberal censorship law. And of course, there's been a lot of concern about Bill C-9. I'm joined for this emergency town hall by my colleague, Josh Dehaas, who is the interim litigation director. And I think what we're going to do today is we're going to play a little bit of good cop, bad cop. I am the bad cop. I'm going to be here with the bad news about the bill. And Josh is going to tell you a few good things and explain why all may not be lost. We may still have some opportunities to make some changes. So now let's get right into it because we only have about an hour and this is a detailed bill that we need to talk about. So a lot of people are concerned about C-9 and for pretty good reason. About 30,000 people have used our online forum to contact their members of parliament about this bill. And I'm going to get into some of the responses that we've received to that as well. But let me explain where things currently stand. On March 25th, the House of Commons voted on the final text of the bill, and it has now gone to the Senate. And first of all, they did change a few things in a positive way, and Josh is going to talk about that. But I'm going to start with the negative parts of the bill, the things that they have not changed or that they made worse. And I think the one that you all know that they made worse and that concerns the most people, and is probably the reason you're here, is the removal of the good faith religious defense. So I'm going to explain what's going on with that. So the good faith religious defense is what exists in the law right now before C-9 is law. And it is in section 319 sub 3 of the criminal code. And it says the following. I'm going to read exactly what the text of the defense says. So it says, no person shall be convicted of an offense of willful promotion of hatred if in good faith they expressed or attempted to establish by an argument an opinion on a religious subject or an opinion based on a belief in a religious text. So the government removed this defense. They did add a strange clarification provision. So I'll read the clarification. For greater certainty, nothing in subsection 319 sub 2, which is the willful promotion of hatred in the criminal code, nothing in that section shall be construed as prohibiting a person from communicating a statement on a matter of public interest, including an educational, religious, political, or scientific statement made in the course of a discussion, publication, or debate if they do not willfully promote hatred against an identifiable group by communicating the statement. So they removed this defense and added this confusing clarification, and this is a terrible mistake. The religious defense in section 319 sub 3 was part of the original bargain when Parliament created Canada's hate speech laws back in the 1970s. When they debated this, the defense was included after significant controversy about concerns people had at the time of criminalizing faith. And Parliament at the time, back in 1970, recognized that religious expression can involve symbolism, metaphor, moral language that the state just shouldn't be policing. And another reason it's a huge mistake to remove the defense is that the Supreme Court actually relied on the defense when it upheld the constitutionality of the willful promotion of hatred provisions. So in the case Keegstra, which is a famous hate speech case, in that case, the Supreme Court said that the hate speech offense was minimally impairing on the right to free expression, in part because of the presence of the religious defense in section 319 sub 3. So in other words, the defense helps makes the law constitutional, and removing it actually jeopardizes the constitutionality of the law. And another thing I think it's important to acknowledge is that limits on speech, they really only ever expand. They very rarely retreat. The government has said that criminalizing portions of religious texts is not their intention. But I think we need to ask, how long until C-9 isn't enough? How many years until we're back here arguing against new and even more extreme restrictions on speech and religious speech? And beyond the constitutional risk that, that removing the defense could actually collapse the constitutional floor, beyond that, I think that removing the defense is a moral and civil liberties mistake because we don't want to empower prosecutors to criminalize the form of a prayer. We know that religious texts across different traditions include metaphors, pleas for justice against enemies and divine retribution, and sort of moral justice, questions of moral justice and cosmic struggle. And that's just not an area where police should be treading. And if we start parsing Psalms or Hadiths line by line in the courtroom, I think we don't really even know why we have a charter to begin with. This is messy speech. It's symbolic. It's very human. And it concerns things like the nature of good and evil, very intimate human questions where the criminal law does not have a role. And I want to go through now, and I've raised all of this before as some of my concerns. I've raised that some of our political leaders are ignorant of religion and religious traditions, sometimes, and I'll get into this, sometimes their own religion. But I want to address some of the responses that we have got from the government. So as you all probably know, we've had this online portal where about 30,000 of you have written to your members of parliament, and we got some responses forwarded to us from Liberal members of parliament, government members of parliament. So I'm going to read a few of them. Some of these are going to be form. We got a response forwarded from a Liberal MP, Heath MacDonald. He's the Minister of Agriculture. And he said, there's information online that this legislation would limit prayer or clergy, that members could be arrested for merely reading from scripture. And MP MacDonald said, if I heard this out of the blue, I'd be furious, but I'd like to assure you that isn't true. Let me be clear, this bill does not criminalize religious teachings or scripture. Freedom of religion is a constitutional right that is fully protected under the Charter. The bill was amended to make clear that sermons, religious teachings, and good faith discussion of scripture is not criminalized. So that's his response. We also got a response from Member of Parliament Anthony Housefather, who's on the Justice Committee, and he wrote, regarding religious expression, freedom of religion remains fully protected. The removal of a defense that has never successfully been used does not mean somebody would be prosecuted tomorrow that could not have been prosecuted yesterday. So let me go through each of those points and tell you what I think. The first point is this claim that this legislation would not limit prayer or clergy or result in charges from reading from scripture. The second point is that the bill was amended to make clear that good faith religious discussion and scripture is not criminalized. The fourth claim is that freedom of religion is fully protected by the Charter. And the fourth government claim is that because the defense was never used successfully, there's effectively no change. So first, would the legislation limit prayer or reading from scripture or result in criminal charges for those things? And the answer is yes, of course it could. That was the very purpose of the change. So throughout the Justice Committee's hearing, the bloc had fixated on the defense, and they cited specifically a prayer. I think it was a terrible prayer. It was a prayer by an imam in Quebec named Adil Sharkawi at a pro-Palestinian rally. And in that prayer, this is the part people want criminal charges for. He asked God to kill the enemies of the people of Gaza and take care of Zionist aggressors. Those are his words. And I condemn those words. I think they were rightly condemned by a lot of people. They're grotesque. Personally, I believe it is evil to pray for the death of people. But I don't think that we should be criminalizing the form of a prayer, even one we think is wrong. Seems to be some belief among the bloc and apparently among the Liberals that Sharkawi was not prosecuted because of the religious defense. That isn't the case. Sharkawi was not charged because his speech actually didn't rise to the criminal threshold of willful promotion of hatred. The RCMP investigated his speech, and they reached that conclusion that there should be no charges. And that was reviewed by three prosecutors who also agreed. Um, I'd like to add that there are also a lot of people who may pray for some sort of divine justice. And that is actually what the bloc was concerned with. They were concerned with criminalizing a particular prayer. Now, maybe we don't like the prayer that Sharkawi prayed. I don't, but I don't want the government to say, I think if they said they could criminalize him for praying for the death of the enemies of the people of Gaza, they could criminalize people for asking for other types of divine retribution or divine justice. Um, Now, as for would Bill C-9 criminalize scripture? Well, we know from what committee chair Mark Miller said at Justice Committee, he does view certain portions of the Bible as hateful. Chair Miller said during the Justice Committee hearings to the director of Christian Legal Fellowship that in Leviticus, in Deuteronomy, in Romans, and I'm quoting him, he said, and other passages, there is clear hatred towards homosexuals. I don't understand how good faith can be invoked if someone is relying on passages of the Bible. And then he clarified this statement on X, stating, Miller said, I say this in particular because I am a Christian. There should be no defense to the crime of publicly inciting hatred because, for example, someone relied on Leviticus or Deuteronomy, which prescribe death to homosexuals and adulterers. It's as simple as that. That is Liberal MP Mark Miller's words. Now, of course, Christians do not call for the execution of gay people. That would be contradictory to the teachings of Jesus to do so. And I think that this shows the nub of the problem. Political leaders, judges, police, crown attorneys, they're often quite ignorant on matters of faith. In Mr. Miller's case, apparently he didn't even have a good understanding of his own faith. So when the government says no one will be prosecuted for quoting scripture, but then their chair literally quotes scripture and calls it hate, I don't believe them. I think he's literally telling us these are portions of the Bible that I believe are hateful. That's what Miller is saying. And legally speaking, the way Bill C-9 works is that if you were to use scripture to say something that the government believes willfully promotes hatred, you can be prosecuted. To put it very bluntly, no matter what the liberals claim, it creates a real risk of criminal prosecution for quoting scripture. Even if the liberals don't think that the law will result in prosecution for this, the text of the bill would permit that. And courts rule on what the text of the bill says, not on what the liberals say in speeches. And even if we are to say, look, let's give the government the best faith interpretation of their intention. Maybe they don't want to criminalize ordinary speech by mainstream political figures. Even if they don't want to do that, there's still a major problem because I think removing the defense will invite investigations, charges, and prosecutions against non-mainstream figures. So the example I've given before is of this situation that happened in the summer with this American Christian worship singer named Sean Foyt, who he came to Canada for a series of performances. Politicians and police used every tool in their toolkit to shut down his services. They cited public health and safety concerns, permitting, things like controversial speech. Controversial speech is permitted in Canada. And, I understand some people might be offended by Foyt's comments, which are conservative and provocative. There is not a right not to be offended. What happened with him ultimately was that in Montreal, police entered a church where he was performing a worship service. They shut down the service and they fined the church. Now, that was with the existing law. It wasn't a criminal penalty. But imagine what this government would have done, what prosecutors, what police would have, and what courts would have done if they had C-9 available to them. Even though none of Foyt's speech is even remotely close to the line of criminal hate speech, I think that if the defense of religious faith did not exist, there would have been an open invitation to bring a prosecution against him. And even if one wasn't brought, I think that there's a lot of confusion. It would create a lot of confusion. It would compel politicians who just don't like non-mainstream political views to call for criminal charges for the commentary that they don't like. Now, the second claim that the government has made is that the amendment makes it so that good faith religious discussion and scripture is not criminalized. And my response to that is that the amendment just adds confusion. Now, remember, they removed the religious defense and then they put in this bizarrely worded clarification statement. And I'll read that again. I read it at the top. It says, for greater certainty, nothing in subsection 319 sub 2, which is the willful promotion of hatred, shall be construed as prohibiting a person from communicating a statement on a matter of public interest, including an educational, religious, political, or scientific statement made in the course of a discussion, publication, or debate if they do not willfully promote hatred. This is just circular. It is not a defense the way the original 319 sub 3 was. It just says you can be charged with willful promotion of hatred no matter what you say, even if it's religious speech. That is what the new clarification says. So not helpful in any way, adds confusion and uncertainty. Now, the third claim the government has made in their responses to our letters everyone's been sending, they say the charter protects religious freedom and expression, so the bill doesn't change that. We have a charter. This bill doesn't change the charter. Religious freedom is still protected. I mean, well then, since the charter protects us, I guess the government never passes unconstitutional laws and we can all, Josh and I can just quit our jobs because the government can't possibly ever do anything that violates the charter. I'll let the judges at the Supreme Court know as well because they can stop striking down unconstitutional laws because the government never does anything unconstitutional. I mean, give me a break. This is not a response to our concerns at all. The government passes unconstitutional laws all the time. It is literally our job to sue them when they do, to fight back the way we're doing with this bill. And courts strike down laws all the time when they violate the charter. So this is an absurd argument and an absurd response. And then finally, the last claim that the government has made with respect to the religious good faith defense being removed is they say the defense has never been successfully used, so we don't need it. And it is true that the defense has never been successfully used, but that actually undercuts the government's argument for removing it. If it has never been used successfully, why would you need to remove it? What problem is it causing? It exists to prevent the criminalization of faith. The existence of the defense is there in part to prevent the prosecution of religious speech before it begins, to prevent the laying of charges. Because laying charges, even if you're not guilty of an offense, it comes with consequences. You can lose your job if you're charged with a criminal offense, even if you're not guilty. You face stigma, even if you're not guilty. It comes with shame associated with being criminally charged, and you need to hire a lawyer and pay thousands of dollars to defend yourself from criminal charges. And to avoid all of that, many people of faith may stop speaking to avoid that. That's what we call a chilling effect. So faith communities are really at risk with this legislation, and that is why we have been urgently writing people or asking people to write to their senators. And Josh can tell you a little bit more about that. But first, let me just very, very briefly tell you the other two things that C-9 is doing that I have concerns with, which is the banning of certain symbols and the standalone hate offense. So I'll very briefly say a few things about those two issues. On the symbols, to be very clear, the display, what this provision in C-9 would do is it criminalizes the display alone of certain symbols like the swastika, terrorist insignia, the SS bolts. And let me be clear, these are despicable symbols. No one wants to see the swastika or the Hezbollah flag, but there's a flaw in the way this is written and what it will actually achieve. First, we're not actually safer if we don't know what someone down the street from our home thinks. We're safer actually knowing, we're better off knowing who holds a disturbing opinion so that we can either openly confront that viewpoint or we can stay away from a person like that whom we probably don't want to engage with. A second problem is that existing hate propaganda offenses already capture the use of symbols if those symbols are used to willfully promote or incite hatred. And the third problem with prohibiting these symbols alone, the display of symbols alone, is that it will capture too much expression. A lot of rallies of across the political spectrum will incorporate people using these symbols as a comparison to their government. I personally think that this is foolish and distasteful. I think it's inaccurate to compare any Canadian parliamentarian to a Nazi or a terrorist. But we often see these comparisons being made by disaffected citizens who are exercising their freedom of expression. And sometimes these comparisons are made using these symbols. And it's not uncommon. We do see that type of speech. I think now that type of speech, these symbols alone, even if it's intended to say, I don't like Nazis and I think my prime minister is behaving like a Nazi, that speech is now going to be captured. My personal views, I don't like that. I think it's foolish and distasteful, but I think you should be entitled to make a point like that. My last comment on C-9, the problems, is with the standalone hate offense. The C-9 would allow for basically the duplication of criminal offenses. So if you have committed any offense under Parliament and the belief of the police and the Crown is that you violated that act of Parliament and the violation was motivated by hatred, you can now be charged with an additional offense, an offense motivated by hatred. And we don't need anything like that. The law as it stands now already treats hatred as an aggravating factor at sentencing. And if an offense is motivated by hatred, the sentencing judge takes that into account and can impose a more serious penalty. And I think that is how it should be. But C-9 proposes this new standalone offense that allows this layering on top of another offense. And as I said, it's not confined to criminal law. Bill C-9 proposes that everyone who commits an offense contrary to an act of Parliament that is motivated by hatred is guilty of that second separate offense. So think of the Canada Human Rights Code, the Canadian Labour Code, or if the government were to bring back the online harms legislation, could violate under C-9 violations of that type of act, including through speech, could result in criminal sanction for speech that's actually below the criminal law standard. I think that there's a real risk of that. And I think a lot of you might be familiar with a recent case involving a man named Barry Neufeld from British Columbia, who was just fined $750,000 for non-criminal speech that violated BC human rights legislation. If BC human rights legislation was subject to C-9, I mean, it wouldn't be because it's a provincial act of Parliament, but if we had a federal version of that, Barry Neufeld wouldn't have just been fined $750,000. He could actually have been found under C-9 criminally liable as well if there was the right underlying legislation. So those are my bad cop concerns with Bill C-9. And now we have Josh is going to be good cop and he's going to tell us a few things that were improved and what we can do, because things were improved as a result of our advocacy and we want to keep pushing because the bills of the Senate and changes are going to be possible. Josh, why don't you tell us about that?
Yeah, so I'll get into that, Christina. I just want to say first, I've noticed a couple people put questions in the chat, and I shut that down just for privacy reasons. So, some people might not want their questions seen, but you can still start putting questions to us in the Q&A, and I'm going to tell you a few things, and in about 15 minutes, we'll start answering those questions. So if you have questions, go to the bottom of your screen and click on the Q&A, and then we, the hosts, will see those questions and we'll try to answer as many of those as we can. Okay, so Christine talked about there being some good news, and I like to think of this as less bad news. So I'm going to go through some of that. So the first bit of good news is that the version that passed doesn't lower the statutory definition of hatred. Okay, so I'm going to explain that. The bill would add a statutory definition of the word hatred for the first time, which is what police and prosecutors and judges would need to consider when they're laying hate speech charges. So those hate speech charges Christine talked about that will no longer have the good faith religious defense. And up until now, hatred, that word in the criminal law, had been defined by the courts, by judges. And judges actually put a pretty high bar on what counted as hatred. But the Liberal government, when they introduced this bill, tried to lower that standard in the statute. So the provisions that this would apply to, I'm talking about, are the criminal hate speech provisions. They are public incitement of hatred, which means communicating statements in a public place that incite hatred against an identifiable group. So specific groups like race, gender, sex, gender identity, etc., where that's likely to lead to a breach of the peace. The second one is willful promotion of hatred, which is communicating statements other than in private that willfully promote hatred against an identifiable group. And the third one is new. It's from 2022. It's willful promotion of anti-Semitism, which is the crime of communicating statements other than in private conversation that willfully promote anti-Semitism by condoning, denying, or downplaying the Holocaust. And by the way, the Liberals haven't said yet whether or not they're going to move forward with an NDP proposal that would add a fourth hate speech crime, which is called residential school denialism. And specifically, this would make it a crime to communicate statements that willfully promote hatred against Indigenous peoples by condoning, denying, downplaying, or justifying the Indian residential school system in Canada, or by misrepresenting facts related to it. So this definition would apply there too if that becomes law. Okay, so the good news is that as the result of advocacy from the Canadian Constitution Foundation, from other civil liberties groups, and in particular from a couple of conservative MPs, Roman Baber and Andrew Lawton, as well as pressure from people who wrote to their MPs using the CCS forum, this original definition that they had chosen that would have lowered the standard is no longer in the bill. So what they had wanted to do is change the definition of hatred to merely an emotion that involves detestation or vilification that is stronger than disdain or dislike. And what we said is, no, 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 you have to follow the courts. And what they said is that hatred means an emotion of an intense or extreme nature that is clearly associated with vilification and detestation. And having those words extreme and intense is really important here because it reduces the risk of going to jail for essentially what is just speech. So consider the definition of vilification that the Supreme Court's given us. They say vilification means accusing a person or a group of disgusting characteristics, inherent deficiencies, or immoral propensities, which are too vile in nature to be shared by the person who vilifies. If you take out that extreme or ardent qualifier, vilification and therefore, hatred or hate speech might just be things like saying, all men are pigs. I don't believe that. Americans make me sick, or, religion X is gross because they allow polygamy, just to use some examples. Or to use a more pertinent example, Christine mentioned the Barry Neufeld case, the man who was fined $750,000 for his speech on gender and gender identity. He said snakes are everywhere, and he was talking about elites who he said push a trans agenda. I think that if you don't have the extreme or intense qualifier on there, that might have been considered hate speech in the future. So really important that that all of this pressure from civil society and politicians got that added back in. So that's some good news. We'll still run into all the same problems we have with hate speech, which is that it's quite subjective and it's very hard to tell when your speech has crossed the line, but at least having the extreme qualifier makes it a little less likely that that you're going to see charges. So that's a win for free speech, even though overall it's this bill is still a big problem. Which brings me to the second bit of good news. So this version of C-9, unlike the original, maintains the requirement for Attorney General consent for hate speech charges. So again, those ones I talked about: public incitement, willful promotion of hatred, and willful promotion of anti-Semitism. These are really unique in that, going all the way back to the beginning, these charges couldn't be laid by police. The vast majority of charges, outside of Quebec anyway, are laid by police. They're not laid by the provincial attorney general. But with this, with hate speech, because it's so controversial, Parliament said we're going to require the provincial attorney general to sign off before we charge someone, before they have to hire a lawyer, before their name gets dragged through the mud as a hate mongerer. And the original bill had attempted to take this out. And that's a problem because police face so much pressure from local groups to press hate speech charges against people who maybe are saying offensive or unpopular things, but that aren't actually hate speech. And they're not always really well equipped to decide, whether it's likely to be over that line, whereas the provincial attorney general is, and they're closer to the community. So this would have just led to way more hate speech charges. So it's good that, thanks to advocacy, this requirement for attorney general consent remains. Okay, the third thing I want to talk about that's sort of good news is that this bill creates a new intimidation offense. And while there may be some concerns around that, the original promise that the Liberal government had made in their platform was that they would create bubble zones, essentially. And they didn't do that. So basically, this provision says that every person commits an offense who engages in any conduct with intent to provoke a state of fear in a person in order to impede their access to a building, structure, or part of a building or structure used for religious worship by an identifiable group, so by people distinguished by race, color, religion, etc., for administrative, social, cultural, or sports activities or events, as an educational institution, including a daycare, or as a residence for seniors, or a cemetery. And it also says every person commits an offense who, without lawful authority, intentionally obstructs or interferes with another person's lawful access to a building or structure referred to in that previous paragraph. So, people found guilty of these intimidation or obstruction crimes would face up to 10 years in prison. They're very serious provisions. But it does come with the defense for lawful speech. The defense maybe could be stronger, but it says this. It says, no person is guilty of an offense by reason only that they attend at, near, or approach a building referred to in the previous paragraph for the purpose of obtaining or communicating information. So these provisions, these are in response, obviously, to the hateful protests that the Jewish community has faced since October 7th, 2023. You've seen a lot of people gathering outside Jewish temples and schools and community centers and saying things that many people perceive as anti-Semitic. And this is sometimes veered into criminal intimidation, but police haven't laid charges. So the idea here is that while police need further clarification that this is criminal intimidation in order to lay charges against people who are, blocking parents trying to drop off their kids at a Jewish community center. The reality, in my opinion, is that this is just redundant because intimidation is already in the criminal code. It's already illegal to intimidate by blockading on a street or a sidewalk, and police just need to enforce the law. So, this appears to be more like a bit of virtue signaling, in my opinion. But it is what it is. So, one concern I'll just mention briefly before I move on is that the government itself internally has said this would apply to Indigenous sacred sites. And so you could see a scenario where people try to protest outside of, for example, the controversial the Indian residential school in Kamloops, where there's a controversy about whether or not children who died in those schools may be buried there. You can see police misusing this particular provision. So that is the concern that exists around it. But I'm not that worried about this one in particular because the Crown would have to prove that intent to provoke a state of fear in order to impede access. And I put this in the good news column because, like I said, there was talk about bubble zones, and bubble zones are clear free speech and protest violations. These are geographic areas where you're not allowed to express yourself at all on certain topics. For example, we're fighting one in Calgary right now that says you can't express any objection or disapproval towards any idea related to more than 15 human rights grounds within 100 meters of libraries and recreation centers. And we actually just got a decision last week that limited this to just gender identity, sex, and sexual orientation. So it's a bit better. But in any event, you should be able to express yourself on topics like gender identity outside of a library that's hosting a drag queen story hour, as long as you're not doing those things like intimidating or obstructing people. So, long story short, this provision could have been a lot worse, but we still need to worry a bit about how police might interpret and apply it. Okay, so now for the really good news, such as it is, which is that the bill's not yet law. It still needs to go through the Senate, which can make further changes that could protect free speech. It's possible they could remove or they could put back in that good faith religious defense that Christine talked about. So, for those not familiar with how the Senate works, the bill can't become law until the Senate has also voted 3 times to approve it and studied it at committee, just like the House of Commons, which has now done its 3 readings and votes. The Senate by convention can't block the bill from passing, but they can suggest changes to the bill, and they do that sometimes. And sometimes the House of Commons decides to accept those changes. So there is reason to be hopeful that the Senate could make those changes, including dropping the good faith religious defense. And that's because the Senate is mostly liberal appointed. There's no Bloc Québécois senators in the Senate. Plus, the Liberals could have a majority in the House after April 13, and that means that they would have the vote to pass this, without the good faith religious defense more easily anyway. And so that's why we think it's important that you write to your senator using the form on our website. It's right at the top of our website, the ccf.ca. And then a second scenario I'll talk about where the bill could die or be improved is that there is a possibility that the Liberals prorogue Parliament after the by-elections on April 13th. So this would happen if they only win 2 out of 3 seats, which would give them just a 1-seat majority. There are, some scholars out there who say they would need to prorogue if they only had a 1-seat majority, because that would allow them to redo the committee appointments and give themselves a majority on committee, which is very important for them. And if they did so, then they would have a majority on the committee, and they might be willing to get rid of or put back in the good faith religious exemption, since it's proved so unpopular, and especially if people continue to write to their senators and let their MPs know that they don't agree with removing that defense. So it's not over yet. Use our forum on the website, send it to everybody that you know who might be interested in this, and we'll just hope for the best. So that's all I wanted to say about that. I see questions are starting to come in. Christine, do you want to go ahead and pick a question that you want to answer, and then we'll go through those.
Yeah, okay. Let me see. Is there any protection for conversations in private homes? Yes. So both the willful promotion of hatred and willful incitement of hatred have a requirement that the speech be in public or published. So private conversations would not fall under the criminal law. Um, if the bill gets passed, would it be grounds for changing religious texts? Uh, they then give some examples from different religious traditions and outline. Yeah. So no, it wouldn't call for religious texts to be changed, but what it could do, and which I've tried to explain, is that if a religious text is used and the government, so the police or a crown attorney, believes that the religious text is being used by an individual to willfully promote hatred, then that can be grounds for a charge. So it wouldn't say you, require the text to change, but it may result in people of faith not wanting to uh, speak publicly about their faith or their beliefs. And that's what the good faith religious defense was designed to to prevent. Uh, it says, "Who in their right mind would vote for this bill given all the laws that already exist to deal with hate speech?" I agree. I think that I actually think what happened in this case is that this is an initiative of the bloc. The removal of the religious amendment is an initiative of the bloc. The rest of the bill is an initiative of the liberals, but they want their bill passed, and they're willing to make this concession to the bloc on the religious amendment, the religious defense, in order to get those other things that they want in the bill. That's my take on it. Josh, what do you think?
Yeah, so I agree with that. I just wanted to say, so if you're having trouble finding the Q&A function, it might be hidden under More if you've minimized your screen. If you have your screen full screen, you should be able to see it right at the bottom with the question mark. Otherwise, it'll be under More. I see a question here from Janice, and it says, "What about protesting drag queen story hour outside of libraries? People have been arrested for that before, so could they now also be charged?" So the only arrest that I'm aware of is related to the bubble zone in Calgary that I mentioned briefly, which specifically says you cannot protest at all about gender identity. And so in Calgary, if you're 100 meters or less from the entrance of a library recreation center, you can expect to be arrested. Other municipalities have started creating similar bubble zones, so that may also exist in your community. As the law stands now, you could be charged with criminal hate speech if you are meeting that test for willful promotion of hatred. And as I mentioned, the case law has said this is reserved for the most extreme versions of the emotions that described by the words vilification or detestation. So if you're protesting in a way that could be viewed as hatred, meeting that definition of hatred, then you could be arrested already today under the criminal code. What would happen today is if you are, if you're using for example, religious language from the Bible, and you're citing a particular part of the Bible, and you're not being particularly extreme in your language, you would have a good defense, and so it's unlikely you would get charges. If this passes in its current form, it's more likely that you would be charged and convicted if Bill C-9 passes. And so that's the bad news, is that if this does become law, it increases the likelihood of being charged. And the reality is, with hatred, it's this definition created by the courts, and now it would be written into the law, but it's still very, very subjective what is hateful and what is more of a good faith, non-hateful discussion about views on gender identity. So it really depends all on the context, on the words you say. All I can tell you is that, it's going to reduce or increase the likelihood of charges if this bill passes.
So there's a question about where can you find the text of the bill, the final text of the bill. I put it in the chat. I hope you can see that. There is another question. Oh, there's a comment from Andrew Lawton, who's a member of Parliament who's on the Justice Committee. He's saying, "Thank you for your incredible work on this issue. My colleagues and I received quite a few messages from people through the CCF website, and your civil liberties emphasis was crucial from day one, even before the religious defense was removed." So thank you, Andrew Lawton, for that. And thank you for your advocacy that did result in some changes that we had asked for being implemented in the bill. You and Mr. Baber both were really instrumental in that. There's another question that says, what if a person prefaces a verse from the Bible with, I speak this in the love of Christ first? So we cannot give legal advice, but the issue is actually what comes after, right? So um, the issue is if the government believes that your speech, even if it's speech that uses scripture of any faith tradition, and they believe that it is being used to willfully promote hatred, there is no defense of good faith for that anymore. So putting any type of disclaimer, it doesn't change the answer, which is an answer you get from lawyers a lot of it depends on what you say next. So no, that would not, in my view, inoculate you depending on what you say after. Um, the next question is, can the Quebec religion law currently before the Supreme Court impact Bill C-9 becoming law? No, those are sort of unrelated issues. And other people are asking where to get a replay of this town hall. It will be posted to our YouTube channel. So if you go on YouTube and look up the Canadian Constitution Foundation, it's there. Do you want to try any of these, Josh? There are a few that relate to residential schools, which you mentioned already a little.
Yeah, I'll try and explain that. This is a really interesting question. So, if C9 is passed in its current form, will it be possible for the NDP's residential denialism definition to be applied, or would changes need to be made? So, I think that if C9 passes on its own, I don't think that um, the text of that, which would be downplaying. Well, let me just look up the text here quickly. The text of that says that it would be a crime to willfully promote hatred by condoning, denying, downplaying, or justifying the Indian residential school in Canada by misrepresenting facts to it. So, as it stands now, that is not part of the law, and C9 would not add that. That would have to be passed in a separate bill later, and there is a bill that the NDP have proposed, so there may be a vote on that at some point as a private member's bill by a Winnipeg MP. So the short answer is no, and like Christine said, we're not giving specific legal advice. There could be some scenario where what you say about Indigenous people does rise to that level of hate under the current law, but these other things like simply condoning, denying, downplaying, or justifying the Indian residential school system, that's not currently a criminal offense. It only would be if that law passed. And I'll try and answer another one. And again, it's like, people need to understand we can't give them specific legal advice about their situations, but people are asking if protesting abortion in front of an abortion clinic would be considered hate. Again, you have to look at the definitions of hate speech. And so if it was relating to women and it was extreme enough vilification or detestation, it's possible you could get hate speech charges at an anti-abortion protest. But the bigger concern with abortion clinics is bubble zones. And so bubble zones right now exist in many places in the country through provincial laws and also in some cases municipal laws. And they say that within a certain distance of an abortion clinic, you can't protest against abortion at all. So those are separate laws. They're not hate speech laws. They're bubble zones. And our concern was that there would be a federal bubble zone. But this bill, thankfully, doesn't do that. So that's a bit of a different question. But just be aware that those laws do exist, and you can talk to a lawyer if you want to figure out whether there's one in your community.
I can answer this one. This question is, will the law be retroactive? No. There's a constitutional problem if a law is retroactive. A criminal law cannot be retroactive. So it will not be retroactive. There's another question about religious speech related to homosexuality. And it asks, what if a pastor says homosexuality is a sin or marriage is between a man and a woman in teaching his congregation, but is not promoting hatred towards homosexuals? Is this considered hate speech? So part of the issue that we have with hate propaganda, hate speech laws broadly is that the definition of hatred, as Josh walked you through, is very subjective. So, um, I mean, if the conclusion is that there's no willful promotion of hatred, then no, it wouldn't be a criminal offense. The question is always who is defining what is hatred, who's defining what is a willful promotion of hatred, and what exactly is being said. So, it may be the case that the pastor does not believe that he's willfully promoting hatred and that his congregation does not believe he's willfully promoting hatred, but certain communities do think that it is willfully promoting hatred, and the police and the crown and judges may conclude that certain speech, depending on what it is willfully promoting hatred, even if that's not the belief of the person making the statement. I mean, that is almost always the case in these hate propaganda offenses. The people who are charged with these offenses always say, "I'm not intending to promote." They don't always. Sometimes they say are promoting hatred, but often they'll say, This is my belief. This is true. I'm not trying to promote hate. This is a fact." And so that's the problem with criminalizing opinion more broadly. So I think the answer is, as I said, is always it depends. So this question, if a pastor says these things and he doesn't think he's promoting hatred, would it be considered hate speech? And it very well could be. Josh, do you want to add anything there about the sort of squishiness of this definition of hatred, which the liberals actually had tried to lower?
Yeah, I mean it's a difficult definition because you essentially just start getting into synonyms for hatred. You say, well, hatred is vilification. Okay, what's vilification? Hatred is detestation. Well, what's detestation? I mean, I earlier read the court's view of what counts as a vilification. So what's extreme vilification? That's over the line. It's not really clear, and what the court has said in a decision called Watcott from 2014 is that you look for things like the hallmarks of hatred. And there's a list of hallmarks of hatred, which are signifiers of what might be hate speech. So just because, somebody's speech shows these hallmarks doesn't necessarily mean it's hate speech. But
Yeah,
the
like
court,
the example you gave of Barry Neufeld talking about the snakes. The
snakes is one of the
snakes was elites he was talking about, actually.
Yeah, so calling a group of people snakes, that's classic in anti-Semitism, or another one that's classic in anti-Semitism is saying that a group of people, Jewish people, want to control the world or take over the world, or that they have some, secret cabal. These are all considered hallmarks of hatred, but then there are lots of instances where, for example, just, calling people snakes is not actually anywhere close to the definition of hatred. So it shows the whole problem with having criminal laws for hate speech is that it's always somewhat subjective, and that chills speech. That when people don't know what they can say um, without potentially being charged, then people can't have conversations about really difficult topics like gender and sports or immigration and important conversations that we need to be able to have as a society. I will just comment. I see a question here that I think is worth answering, and it's just comment on publishing. Uh, for example, in Finland, there was recently a prosecution for a written book. So this was a book somebody had published, I believe, that was critical of gender identity and sexual orientation. Willful promotion of hatred, it does apply to the written word. There's there was long a debate about whether or not, for example, social media is a public place or is not in private conversation. And in the last few years, attorneys general have started to decide that that is a public place. So if you post something on Facebook, for many years you wouldn't be charged for that, but all of a sudden, Quebec's attorney general started charging people for Facebook speech online, and those courts upheld those charges. And now we're seeing it in other provinces. There are charges in Ontario and Manitoba as well for things that people have posted on Facebook that the Attorney General believes rises to that level. There are also provincial human rights codes that make it a crime to publish hateful or discriminatory speech, and the Supreme Court has upheld those. It's using the same definition that we talked about before. Here in Ontario, we don't have that. It would only be against the Human Rights Code if you, for example, published a sign in like a business as opposed to that said no people X allowed here. But you can still publish in the newspaper and not be offside the Human Rights Code. But so it's going to depend on your province unless it rises to that criminal hate speech level. But long story short, yes, it does apply to written materials generally.
There's one last question that we're going to get to. It's about the Canada Human Rights Act, and I briefly mentioned this. So this question says Section 13 of the Canada Human Rights Act was repealed in 2013. I think it might have been later than that. I don't remember. Primarily because critics argued it was too broad, vague, and created a chilling effect on free expression, often targeting speech that did not meet the high criminal standard for hate propaganda. Could the same arguments be made to get C-9 removed? Why would C-9 go through when Section 13 was repealed of the Canada Human Rights Act? So, the Section 13 of the Canada Human Rights Act was repealed politically. It was repealed by a government who disagreed with its use and abuse, in particular in response to complaints that had been made at provincial and federal human rights commissions about the journalism of Mark Steyn, in particular, an article he wrote for Maclean's magazine. And the Harper government repealed that provision. The Trudeau government had actually proposed bringing it back in a piece of legislation called Bill C-36, which is the which was introduced before C-63, then withdrawn. I think that there is a chance that something like that could return under the Carney government. We don't know 100%, but the Trudeau government did try it. And that provision that allowed for prosecution under human rights legislation for publications exists in certain provinces. That's the legislation Josh was just referring to. And it's actually the legislation that resulted in that $750,000 fine against Barry Neufeld. Now, if Section 13 of the Federal Human Rights Act was reintroduced, we would have that danger associated with the standalone hate offense that's in C-9. So if we had Section 13 of the Canada Human Rights Act and someone violated, you could actually then layer on top of that offense, that human rights offense, a criminal offense for an offense motivated by hatred. And that's a real risk. And that's one of the reasons we've been warning people against the standalone hate offense. Is there any, look, C-9 could be repealed by a future government, the way Section 13 of the Canada Human Rights Act was. But as I said, a new government that comes in, if it's of a different political party, would have to say, are we going to prioritize this instead of, the many, many other issues that a new government might want to spend political capital on? Because, they'll have to bear the political cost of saying, we're going to repeal this legislation. They're going to have to fight about it. There will be, political heat that they'll take for it, and they may choose not to do it. That's why I said in my introductory remarks, we usually only see restrictions on speech increase. We rarely see them repealed. And it's only a number of years before we're going to be back in front of Justice Committee saying, like, with the government saying C-9 wasn't enough, now we need to go further. That's all the time we have. We're already 2 minutes over. I want to thank everyone so much for coming on today to share this. It's a particularly relevant time to be talking about this because for Christians, this is Holy Week, and for Jews, today is Passover. And I think it's so important for faith communities to be engaged in this issue and to be aware of what's happening. And I don't want to leave on a negative note. This is supposed to be a season for hope. And we do have a lot of hope because there is this possibility that the Senate may make changes if we pressure them. Josh, can you just remind people where they can go to send that letter to senators and remind people why this change might actually happen if we put enough pressure on the Senate?
Yeah, so just go to the ccf.ca, so our homepage, and right at the top, it's the very top of our website. You'll see a place where you can click and you can use that form to send a letter directly to your senator telling them your concerns. It takes only a couple of minutes, and the Senate doesn't need to do this. It doesn't need to remove the good faith religious exemption. If the Liberals have a majority in mid-April, then they don't need to worry about the block on that particular issue. And so there's incentive for them to also do the right thing and not move forward with that. So some reasons for hope. And yeah, happy Easter. Enjoy Passover if you're Jewish. And thanks for attending.
Thank you.